Good morning, everyone. I, Dr. Nisha Davra, feel privileged and honored to welcome you all on the occasion of a special lecture to mark the celebrations of World Intellectual Property Day, organized by PG Department of Chemistry under the aegis of Institutions Innovation Council 4.0 of Meherchand Mahajan DAV College for Women, Sector 36, Chandigarh. On behalf of Honorable Principal Ma'am and President IIC, Dr. Nisha Bhargava, Vice President IIC, Dr. Indu Arora, Convener IIC, Dr. Neetu, and Head of Department of Chemistry, Dr. Shifali Dhiman, I take this opportunity to welcome our esteemed speaker, Mr. Vijay Gupta, Advocate Lexentech IP Law Office, New Delhi, on the portals of MCM College.
Thank you.
MCM College for Women was established by DAV College Managing Committee, New Delhi in the year 1968 to commemorate the meritorious services rendered by Justice Meherchand Mahajan, former Chief Justice of India, in the field of law, education and administration. This institution enjoys peerless reputation in the field of higher education and has remained ahead of times with its innovative programs and infrastructure and under the able guidance of the visionary leader Dr. Nisha Bhargava. Today we all have gathered to mark the celebrations of World Intellectual Property Day, which is celebrated across the globe to raise the awareness about the copyrights, patents, designs and trademarks and how they are impacting our daily lives. This program has been organized by PG Department of Chemistry under the aegis of Institutions Innovation Council 4.0 of MCM DAV College. The Institutions Innovation Council of this college is working under the guidance of Ministry of Education, Innovation Cell, Government of India, and they are doing various programs related to innovation in various higher educational institutions by conducting such activities such as webinars, workshops, and several other activities. Before proceeding with the session, it gives me immense pleasure to give the brief introduction of our speaker, Mr. Vijay Gupta, to all of you. Mr. Vijay Gupta is an advocate and registered patent and trademark attorney in India with about 25 plus years of experience in the field of law and intellectual property. He is a managing partner of the legal firm Lexentech, which provides specialized IP-related services at global level to attorneys, corporations, and individuals. His present job profile includes management and administrative responsibilities, decision-making and developing strategies for new opportunities, and so on and on. He has given various presentations on IP issues and has published a number of articles in the field of IPR. He was appointed as a jury member by the Times of India Group to judge the semi-finalist contestants of the Lead India program. Mr. Vijay has also headed IP operations of US-based company which provided legal research, writing and patent-related services. Mr. Vijay has completed his bachelor's degree in science with physics, chemistry and mathematics in the year 1994 and master's degree in physics and electronics in communication in the year 1996. He has completed his bachelor's of law and qualified as an advocate in the year 1999. He has also completed a certificate course in the intellectual property rights from IBM. He also holds a postgraduate diploma in the intellectual property rights, postgraduate diploma in the computer science and applications, and postgraduate diploma in the human rights. He is a member of various reputed associations and organizations in India and abroad, including Asian Patent Attorney Association, Supreme Court Bar Association, Delhi High Court Bar Association, and Bar Council of India. Sir, we are very privileged to have you with us today, and we are grateful that you have spared your valuable time and accepted our invitation. Thank you. Now I request everyone to turn on their cameras for a group photograph.
Students also please turn on your cameras.
Thank you. Students can turn off their cameras now. They are required to be silent during the meet. Now I request Mr. Vijay Gupta to begin with the session. Thank you.
Good morning, everyone. Thank you, Nisa ma'am. Thank you, Dr. Saif Ali and Dr. Nisha Varga, Principal ma'am. She's, I think, also chairman of this institution's Innovation Council. Uh, Today, we are celebrating IP Day, and I think it is privilege for me that I am invited to give a brief overview of IPR. So, this IP Day, as Nisa ma'am already mentioned, why this is celebrated, it was started by World Intellectual Property Organization, that is WIPO, in the year 2000, just to create awareness about patents, trademark, copyright, and industrial design, and their impact in our daily lives. And today we are celebrating this 23rd World Intellectual Property Day. And yes, I think this is organized by IIC 4. I think there must be some other division, IIC 1, 2, 3, in different field of technologies of the institutions. So basically, what is IPR? When we discuss intellectual property right, what is intellectual property rights? This is, name itself suggested, intellectual property, a creation of someone's intellect, his mind, his brain, his intelligence. So this particular year, the World IP Day theme is focus on IP and youth innovating for a better future. So let's discuss what kind of property. We know that we are having movable property that include mobile, car, pen, furniture, anything which can be moved. Then we are having immovable properties like land, building, and other sort of things. Then intellectual property. Intellectual property includes creation of individuals' intellect. This includes inventions, artistic work, literary work, cinematographic work, any formula, any molecule, any drug. So all these are the creation of individuals' intellect. And some intangible, this is intangible thing. We can't see, we can't touch because it is in our mind. But when we work on this and implement our ideas and give a shape of something tangible, which we can feel, which we can use, so that is intangible to tangible. Major intellectual property rights or major intellectual properties includes, generally we heard about trademark, copyright, patents, and industrial design, geographical indications. So what is patents? Let me give you one example. Nowadays we are using mobile phone, that is iPhone, Apple's iPhone. This iPhone is having number of different type of intellectual property. For example, if we see the logo of this Apple, this is a logo, this is a brand. So this logo is called trademark. And this phone itself, which is having number of interfaces, number of software in it, and perform particular task, this facilitate communication. So patent is also exists in this. Now the configuration, how this phone is looks, what are the different buttons on this, where is this web camera is placed, what is the ornamental configuration of the shape and patterns on this particular device are covered under industrial design. And the packaging in which it is sold is having number of description about the phone, marketing sort of activities which are also printed therein. So all this sort of material which is in the shape of artistic material or literature form description about the mobile, that is covered under copyright. So basically a particular things can have a single IPR, that may be a patents or maybe a trademark as well, or copyright, and also an industrial design. Sorry, there is a technical issue. Sorry, there is some technical issue. Is I am audible to all of you?
Yes, sir. Yes.
Okay, ma'am. So let me give another example of this. For example, we can consider this Coca-Cola bottle. Here we can see number of IPR are protected by the way of different aspect of this patent. Whatever the formula for this making this cold drink, the process of making and the contents of that particular product is covered under the patents. And the shape and configuration of this bottle, the different sort of patterns here is protected under the industrial design. And the name itself, is it protected under the trademark? However, the Coca-Cola company has not filed any application for the patent grant for the reason because the patents are limited rights which are applicable for 20 years, they prefer to retain the formula as a trade secret. So there is a no limitation on over the time. It is everlasting till they remain to keep it secret. Similarly, there is geographical indications like Tirupati Laddu, Kolhapuri Chappals, Agra ka Petha. So geographical indications basically a product from a particular geography or location. Say basmati rice, it is cultivated in a particular environment on particular temperature. So that this particular right related to geography of a particular location. So geographical indication. So these are different types of IPR rights. Now, what is patent? Patent is so what is patents? Patent is a monopoly rights which gives its creator or its inventor or a scientist who works to solve a particular problem and come with a solution which is new, non-obvious, and which involves some inventiveness. For example, if you develop a drugs for COVID treatment, and there is some property of that drugs or medicines which help in reducing or eliminating the COVID related infections, then you are entitled for getting a patent for that. Patents are limited monopoly rights which gives you monopoly for a particular period, that is 20 years from the date of filing of that patent application. What can be patented? Any invention in any field of technology can be patented, which meets the three criteria. That is novelty, non-obviousness, and industrial applicability. Novelty means if students of your institutions are working on some, they are doing some research on some particular field, they would like to develop a chemical formula or some a product or anything, and which is overcoming the some shortcomings of existing thing, then their idea in their mind must be new. That new means that is not known to other person in the field, and that is also having some industrial applicability. It is not like that I am having an idea that I can create a molecule, I can create a product, and I'm having an idea in my mind, but I cannot implement. I cannot produce that industrially. I cannot manufacture that through a process. So that cannot be patented. For patent, basic requirement is newness, non-obviousness, and industrial applicability. But basically, anything, any product, any process which is having significance over the existing things. It is not like that we are creating something which doesn't exist anywhere. Initially, there were mobile phones. We were not having any camera in that mobile phones. There was some research work due to some different type of research. Mobile camera was incorporated. Then some alarm features were incorporated. Then displays were improved. So the inventors of these were awarded patent for every features, which is initially the camera was having some few megapixels. So that picture quality was constrained, not good. Then nowadays we are having better quality, better technology, 100 megapixel, 200 megapixels camera. So anything which makes the advancement of existing things is entitled for a patent. So basically, if there are 10 things of a particular product in mobile, but you are improving on one particular aspect of that, and which is useful over the existing technology, then you are entitled for a patent for that. Now, because this program is organized by the chemistry department, so I would like to give brief details about what sort of chemical patents are there. A chemical patent, pharmaceutical patent, or drug patent uh, is an invention in the field of chemical or pharmaceutical industries. It is valid for 20 years, or basically in this pharmaceutical and chemical industry, there is lots of problem concerning the copying of that formula and producing duplicacy of that particular product in the market. And when an institutes or scientists are working on a particular problem, then lots of efforts and lots of money is spent on these working and developing a particular things. And someone is copying very easily and taking benefit of the same. This means the creator of this is deprived of their rights. So to protect the rights in the invention in this field, the patents are recommended and patents are filed. And once the patent is granted, the owner of the patent is having monopoly or exclusivity to exclude others from manufacturing or marketing.
So your presentation has stopped. Wait, students, I think the speaker has some technical issues. Please wait for a moment.
Sir is facing some power issues. All please remain online. Thank you.
Hello, I am audible.
Yes, sir.
I am very sorry. There is some power issue, power cut issue.
No,
I was
no
disconnected.
problem. No issues, sir. You can continue.
So, yeah, I was discussing the chemical patents, the patents in the field of chemical industry or chemical science. So, chemical patents help scientists get an exclusive right to market, use, and sell specific chemicals, compounds. The patents extend to the development, experimentation, uses, and marketing of chemical compounds in various substances and products. A chemical patent helps the researchers to protect their discovery. A type of chemical patents. Whenever you are working on some invention in your field and you think that you
Sir,
are having
excuse me.
an idea that in your mind, but you would like to implement your idea in the lab and some other places, but you are having good idea that you are very confident that yes, this is very useful, then you can do one thing. You can file a provisional patent application. There are 2 3 types of patent applications which you can file for your inventions or ideas. That is provisional patent application, ordinary patent application, and PCT patent application. In the provisional patent application, you are merely required the basic things about your idea, basic principle, and you are afraid of that your idea may be copied. So it is always recommended to file a provisional patent application with limited information. Even your invention or discovery is not completed with the patent office. And you will be protected, your idea will be protected from the date of filing of that patent applications. It will give you a priority date. Priority date is the date which gives you protection from the date of filing. There is a seal or a stamp of patent office, date and time of filing. And someone else is coming with the same idea and he is filing a patent a minute later after your filing, you will be having priority. Not in India, but around the world. So you can file a provisional patent application. But if you have completed your research, you have developed a molecule or any other product, you can file a complete patent application by disclosing complete information about your that innovation, that how it works, what are the different ingredients or components of this, or maybe the process, what is the process in the Indian patent office. And if you think that your idea is having commercial significance across borders, and you would like to protect your invention in Europe, US, and other many countries, then you can proceed through a patent cooperation TT route, PCT routes. So by filing a single application, even in India, India is also the receiving office of that PCT route, you can claim the priority over 130 countries who are the signatory of this PCT, patent cooperation treaty. Most of the inventions are chemical inventions. Basically, any invention uses substances or is made of something, it is likely to have a chemical piece of puzzle. So most of the invention in the field of generally includes something which is related to chemical field. In this particular chemical field, there are 3-4 types of patents can be granted. That is, one is the composition of a claim. So composition of claimed matter. This is related to a recipe for preparing a tea, which is useful for diabetic cure. And there is some composition. You have included a particular matter or something which is generally not used and which is your innovation, which helps in eliminating or controlling the diabetes. Then you can file a patent for your composition. The second is product by process patents. Suppose if you have developed a product through a particular process which involve a particular temperature or particular environment or anything which is new, and that particular step helpful in creating something useful and which makes the product novel, non-obvious, then you are entitled for to have a patent for that also. For example, if you created a soya milk yogurt, and if this generally there is a patent on this soya milk yogurt, what its scientist, what was this soya milk yogurt? The scientist who developed this soya milk yogurt, he claimed that this is useful in the treatment of cancer. So it cures cancer disease, and it is processed through a particular temperature, environment, and time, which created some particular quality of this particular product, which is helpful in cancer treatment and cancer cure. So the patent is also granted. It is also granted for compound. If you have created a compound or a molecule, say vitamin C, The compound of vitamin C could be claimed based on a specific chemical makeup or structure. So basically, anything and include inventive step. Inventive step means this is the basic requirement of getting a patent or securing a patent. Inventive step is the feature of invention or innovation, which include an inventive step that is not obvious to a person skilled in the art. It is not like that product which is known, and a person in the same field of art or technology can say, "What is this? This is very obvious. You are simply including two, three things and making this there." Then patent is not granted. Inventive step is a feature of your innovation which is having some advancement over the existing product or existing technology. And this advancement or improvements makes it unknown at the time it is disclosed and useful for others. Then the patent. So patents, a patent can be granted for a process to manufacturing particular task. If that process is global or a product that is produced by that process. So anything which is lost to friends. Hello, I'm sorry, really, there is some issue at my end, and I'm very frequently disconnecting. Is I'm audible? Hello.
So yes, we can hear you.
Okay. So, what is patentable? Anything which is new. I was discussing this invitation card, and I'm not sure whether whatever I tried to convey reached to you or you, because again I was disconnected. So I was discussing this invitation card, ma'am. I think I was disconnected, so it was not conveyed to you. So let me remind again. Let me discuss it again. Is I'm audible, ma'am?
Yes, sir. Yes.
Okay. So I was referring this card. So this card itself is having copyright in it.
Sir, excuse me, sir. We can't see the screen. Is it possible to share the screen?
One moment, please. Can you see it now?
Yes, yes, sir. Now.
Okay.
Thank you.
I was discussing what type of intellectual property that exists in this particular invitation card. There is a logo of Institutions Innovation Council. So this logo can be protected by the way of trademark, this particular logo. This is called logo or device mark. Then there is a disclaimer on this copyright, all right reserved. So basically, why this is copyright is subsists in this. This particular invitation card is having particular type of design, that artistic design, a literature, a logo. So copyright is also there, subsists in this. Trademark is also there. And two types of copyright exist in this particular card. One is literature, literary copyright, which is whatever is printed or written in the literature form is protected by the way of literary copyright work. And the design, patterns, color combination, logo, all this protected by the way of artistic work. So copyright is also exist in this. Then there is another aspect of the intellectual property right, which is trade secrets. Trade secret generally when we don't want to disclose our anything which is very useful or which can be copied, then we can keep that things as a trade secret. For example, the formula of Coca-Cola drink is not yet disclosed, not known to anyone except few people in their team or management or owners, because patents are granted for 20 years and this formula is existing as a trade secret since hundreds of years. So you can keep this trade secret route if there is an invention, there is a molecule or anything, how you have developed that product through a process or particular mechanism. You don't want to that I don't want to file that because it may be copied or it can be explored after 20 years, because patents give you monopoly rights for a particular period that is 20 years from the date of filing of your ideas. So you can keep that formula or that particular things as trade secret. Trade secret can be any invention, idea, survey, or any financial strategy or any database. And there is, so and all these patents, trademark, copyright, and industrial designs are governed by Ministry of Commerce, Government of India. The Controller General of Patents and Trademark, whose head office in Mumbai, is the chief of this particular field, IPR. And we are having offices of patents and design offices in Delhi, Mumbai, Calcutta, Madras, and similarly for trademark in the metros. And geographical indications, if we need to register particular things as a geographical indications, just Alfonso mangoes, Kolhapuri chappals, Agra ka peta, then there is a office which is based in Chennai, which deals this. And there is also a patent information system of Government of India. Then WIPO, World Intellectual Property Organizations, which governs rules and treaties concerning the protection of patents, promotion and protection of IPR. These are the organization, and WTO also deals with the aspect of IPR. Patents are valid for 20 years from the date of filing or disclosing it to the government office. No extension, nothing. And after 20 years, whatever you have patented, that would be in public domain. So many of the generic drugs whose patents protection is expired, they can be manufactured as a generic drugs. There is no patents, and any manufacturer is using that formula, manufacturing that drugs, is not required to pay any royalty, any license fee to the original innovator or scientist. There are some issues, if you have heard about this COVID vaccines, when there is a requirement of the formula of that. So there were lots of discussion regarding the waiver of IPR rights. The developing country or poor countries, or the country like India, who had requested the US and other European countries, or drug manufacturers including Pfizer and other COVID shield, please allow us, or please waive off your licensing fee or licensing requirement, so that we can manufacture and produce these drugs for the welfare of mankind. So this licensing and this fee is also one of the aspect. So this is regarding this, the IPR. IPR based, let me summarize this. IPR includes patents, trademark, copyright, industrial design, primarily. Patents are granted for the innovations which makes a particular product or machine or anything useful, which involves an inventiveness, and which is not merely a combination of two existing things. And basic requirement is inventive step, that the feature of that innovation which is not obvious and which shows sufficient in advancement over the existing technology. So patents are granted for innovations. 3 types of patents can be filed. Provisional application, when you are in the initial phase of developing, you are having an idea and you are in the initial phase of developing something which requires some time, then you can file a provisional patent application. Your protection is started from the date of filing that provisional patent application. It gives you 12 months time, and within 12 months time, you can explore your invention, different aspect of that, and complete your invention. And within 10 months, you can file complete patent application by disclosing all details about your invention. If you think your idea is great idea and it's a potential across the board, then you can file a PCT route. So these are the 3 type of filing is required. The Chandigarh, Punjab, these are jurisdiction under the Delhi Patent Office. So patent application filed with the Delhi Patent Office. If you like to trademark your brand name, your institution's name, or any logo, or your firm name or your company name. You can protect your that name or logo by the way of trademark. So this is second type of IPR. Then copyright. Whatever any book, any literature, any music, any art, or even software programs are protected by the way of copyright. Then industrial designs. Any ornamental feature, any chair, any table, any jewelry, any article which is having some shape, pattern, and configurations which can be protected by the way of copyright. Copyright protection is granted for 15 years. Trademark protection is granted for 10 years, but it will be renewed indefinitely for every further subsequent 10 years. Patent is a monopoly right. Sometimes it is called negative rights because it restricts others from making, manufacturing, or selling the patented thing. So this is only for 20 years. Then trade secret, which you would like to keep secret, and in case of any violation of or any theft of trade secret, you can file a case against the uh, infringer or whosoever is maybe copying your idea, but you have to prove that his secret was with you since this much of time. Then industrial designs. So this is all about this. Now the students in the field of chemical or chemical science, what is the scope of students? By patent protection is required. Patents give you monopoly, exclusivity. If you have developed something, you can give license to others for manufacturing, producing, and selling for the same for a particular time. So it will give you royalty and the license fee of your innovation. So this awards your hard work in developing that innovation. Now, nowadays, there is a great requirement of this chemical field, pharmaceutical students having knowledge about this IPR. In the various pharmaceutical companies, they are hiring the students or the scientists, researchers in this field in their R&D sections. And anyone who is having technical background, he can also try to register themselves as a patent agent, patent scientist, and there is a exam. There is a patent agent exam which is conducted by the patent office, I think twice a year, and this is having two stages, the first stage and second stage.
So can you hear us?
I was again disconnected. So yeah, can you hear me?
Yes, sir. Yes.
Okay. So anyone who would like to file, they can appear adding application, and patent application were international groups, the patents and IPR, and the bodies provide patent protections. Thereafter, the third step is the interview. So basically, we 60% marks are related to the and every year thousands of students, many thousands of students nowadays go specific and pharmacy. And so if you are having a technical degree or PhD degree, coupled with this interesting, that gives you advantage for your recruitment or attachment with different uh, organizations, research institutions, and government bodies. So I think, ma'am, this is what I would like to discuss regarding this idea. And any questions regarding the patent, trademark, copyright, then we can discuss and share more information if required, or we can clarify, because I was disconnected in between many of the times. I don't know what happened today with the power issues.
Yes, students, any questions? Anyone needs any clarification on anything? Sir, I think nobody is asking anything. So let's wrap up the event now. On behalf of respected Principal Ma'am Dr. Nisha Bhargava, Vice President Dr. Indu Arora, Convener Dr. Neetu, and HOD Dr. Shefali, I take this opportunity to express my sincere vote of thanks to Mr. Vijay Gupta for his excellent and knowledgeable presentation on the occasion of World IPR Day. I'm sure this talk might have encouraged and motivated our students for the future career and research prospects. Thank you, sir, for accepting our kind invitation and sparing your valuable time for enlightening our students with your knowledge and words of wisdom. I express my gratitude to all the coordinators, Dr. Rishu, Ms. Sonali, including myself, for the successful organization of this event. Most importantly, I express my thanks to all the student participants who have spared their valuable time and have joined their event and being the patient listeners. Thank you. Thank you, sir.
For this technical issues or glitches, and which caused lots of inconvenience.
No
And I
problem,
hope
sir.
we will work overcome this issue.
Right, sir. Thank you, sir. No issues. Thank you.
Thank you, sir.
Thank you. Students can leave the meeting.